you should re-elect me to our Court of Appeals. I offer a different background and perspective forged in the crucible of 25 years representing working families, children at risk, and small business owners. I became a judge the old-fashioned way. I learned my trade through my practice of 25 years that took me to the trenches of both state and federal court across the state, from small claims court to the Ohio Supreme Court. And now as a judge, I approach each case with an open mind, and I'm dedicated to making the right decision rather than a decision predetermined either by personal or political agendas. I am not a career elected official, nor did I rely on those politically well-connected to achieve my position as State Bar Association president or judge. Rather, I relied on individuals who believed in independent thought, fidelity to the Constitution and precedent, and shared my passion for the law and court reform to help achieve the positions where I could make a difference. As I stand for re-election to our Court of Appeals, I offer a record of achievement of both on and off the bench. I've authored 470 written opinions, including a key opinion upholding the constitutionality of the new form of government in Cuyahoga County, chosen by the people of that county. I've served as a visiting judge on the Ohio Supreme Court and on 4 sister districts across the state by assignment of the Chief Justice. 2 years ago, I was evaluated by the Nonpartisan Judicial Candidates Rating Coalition, and I was the only Supreme Court candidate to receive a perfect 4.0 rating. In the first Bar Association rating poll this year, I received the preferred rating by a margin of 83% to my opponent's 17%. Under my watch as presiding and administrative judge, we reduced our operating budget, we accomplished a staff reorganization, and we have reduced the average time that it takes for an appeal to start and finish from 12 months, sometimes 18 months, down to 7 or 8 months. I thank you for your consideration, and I look forward to your questions.
Hi, I'm Cindy Sasse, and I'm Greg's wife. He has, for whatever reason, delegated this duty to me tonight, so bear with me. As I understand it, I'm going to ask one question of each of one candidate, my second question of the other candidate. Then when we get back to the next set of questions, I'll ask the second candidate first and the first candidate second. So, as long as I can keep that straight, maybe we can go do what we're supposed to do. So, Ms. O'Toole, I think we'll start with you, since we're going alphabetically tonight. Both of you, in responses or written responses to our written questions, have stated that pursuant to the Ohio Constitution, further tort reform is not possible without a substantial constitutional change. Short of such a change, what tools are available to bring litigation costs and expanded use of frivolous litigation under control?
That's an excellent question. Litigation costs track all of us. And a lot of our system is set up very, very formally. When I was on the bench, as well as recently, I worked tirelessly to reduce the cost of transcripts and proceedings, to put more things on the internet so people could see them. In addition, we can do certain amendments and changes to the rules of evidence in cases such as divorce, in cases such as minor disputes and common pleas. We can relax the rules of evidence so that people may not need such intricate rules to hire attorneys. I am against special interests. I feel although attorneys can be helpful, they are also a special interest group. Sometimes they are very vested in prolonging litigation, and because face it, that's their meal ticket. You're paying them. There is no incentive in the system presently for attorneys to keep costs down. I think the bar associations are also a vested special interest, and I think they also work for lawyers and by lawyers. So what I would really like to do is work with our present rules and the rules of court to make things more accessible, to make them a little easier, to keep the cost of transcripts down. And I was diligent in that advocacy after I left the bench, before I came to the bench, because I too was caught in a fairly ugly divorce where I was trapped with high litigation fees. And so I've made that my life goal, to make everything accessible, to make it fair, to allow people to have the courts serve the people and not necessarily the attorneys, the judges, or the clerks or elected officials that are running those courts. Thank you.
Thank you. Judge Stratt?
Thank you. First of all, there are plenty of tools out there for judges to stop what are so-called frivolous lawsuits and what we call vexatious litigators. Vexatious litigators is just a fancy way of saying somebody that's at the courthouse door every day filing suits against their neighbors, against their family, and against businesses. If judges would simply use them. There's what's called Rule 11. For those of you who are attorneys, Rule 11 is very simple. It's a civil rule that says when an attorney or a party signs a pleading, a document, a complaint that's filed in court, that they are attesting to the court and to all of you that they have good grounds to file that lawsuit. And if they don't, a motion for sanctions can be filed and sanctions can be levied against the attorney. In the revised code, there is a section called 232351. It is frivolous conduct statute. There, the attorney and their client can be sanctioned for frivolous conduct. But guess what? There are some judges, and I see it every day in my job, there are some judges that are fearful or they just don't want to deal with it. I have sent back 2 cases in the past year to a lower court and instructed the judge to look at it again and hold a hearing to impose sanctions because there was frivolous conduct. It's that simple. And let me say, standing here as a bar president, past president, I have to say bar associations protect the public. If an attorney is a member of a bar association, statistically they are less likely to commit malpractice, they are less likely to commit ethical violations, and the peer pressure of doing the right thing and having to see that person at a bar association meeting is one of the best protections that you have.
Thank you. I think this time around, you get hit first.
Okay.
Okay. Now, both of you, again, in your responses, expressed the opinion that the citizens of Ohio should continue to have the opportunity to elect judges who serve at all levels of Ohio courts. As I understand it, that means that you believe the citizens should be able to hold their judges accountable for their conduct in office. If that's so, should courts consider popular local opinions regarding particular cases? And if not, how can a system of popular election take into account the conduct of judges?
If I understand the question, Cindy, it's a sort of a 2-part question about election of judges and then accountability and how do you actually shield yourself from public opinion.
My understanding was from your written responses, but both of you said that judges should be elected.
Right.
That that's appropriate. So I went from there to say, if judges should be elected, then does that mean that judges should take into account the opinions of the electorate in rendering their decisions?
No. Judges are accountable to the people, obviously. If you don't like one of our opinions or you don't like what we do, ultimately, you can vote us out of office. But I ask people to step back and say, that's one thing for someone who is in the other branches of government. But what you want from your judge is someone who will have the intestinal fortitude and the intellectual honesty to put aside, number one, they have to recognize their own biases, just as you do if you're sitting on a jury. You have to recognize your own biases. You have to recognize what popular opinion may be on a topic. and ask yourself, am I willing to go against the tide